Okay, so hello everybody. A very good afternoon to all of you. My name is Amisha, and I am today present here to make my presentation on section 14 of Hindu Marriage Act, which talks about the petition for divorce. So the basic question that arises most of the times is to is when to file a divorce petition. Legally put, section 14 says that no petition for divorce is to be presented within 1 year of marriage. What does this actually mean? So when we come down to decode this word, we actually mean that right from the date from when the marriage was first solemnized and until the first year time has been elapsed, no petition for divorce can actually be filed. So what happens when somebody files a divorce petition before expiry of this one period? So what the court says is that it will not entertain such a petition. But again, there are certain exceptions. Court will allow such a petition in case of exceptional circumstances. Exceptional circumstances as in depravity or hardship. That is, in view of the facts and circumstances of the case, if it appears to the court that okay, these are the conditions which actually makes it very difficult for the spouses to live together, the court will grant you a petition. But meanwhile, during the trial, if it appears to the court that the person who has obtained the decree has actually misrepresented or tried to conceal a fact or tried to lie to the court then has two options. It will for either dismiss the entire petition, it will say, okay, no, I'll not grant you a petition, or secondly, it may still grant you a petition. That means even if you have lied to the court will say, okay, we will grant you a petition, but the condition is that this petition, this decree that is granted by the court shall not be effective unless so until this 1 year time period, which has already been mentioned, shall shall be elapsed. That is, it must be expired, and only then the decree which has been granted by the court will come into force. Meanwhile, the interests of the children, if any children is being born out of this marriage, or if there is any possibility of reconciliation between the spouses, that is also taken into concern. So, if on all the basis of all these facts, if it appears to the court that okay, these are conditions of exceptional circumstances, the court will grant you a decree. But meanwhile, what is the object of this section? So this has been a matter of core concern time and again, and this has been described in many of the judgments. In Meghanatha Nagar versus Shushila, the court tried to explain the objective, and it said that what Section 14 tries to do is to prevent the young spouses who come to the court and take help of legal proceedings after every petty fight they have in order to dissolve the marriage. They ask the such young spouses to wait for a particular period of time to try to give certain period of effort to their marriage. Instead of dissolving it, they should actually try to invest in their marriage, and thus it tries to give a fair trial rule, fair time for the spouses to think about their marriage. Also, there is this question of exceptional depravity and exceptional hardship. What does this term denote? So, both of these terms have actually not been defined in the Act, nor has been defined in the section also. But time and again by judicial precedents, the court has tried to explain the domain of these two words. In again the same case, Niger versus Shushila, court says that depravity and hardship, if put in layman language, is actually that particular situation which has been created in the matrimonial home, which makes it very difficult for the spouses to live together. It has been kind of been made like a hell, and living together is certainly not an option for either of the spouse. Also, while referring to the Bauman versus Bauman case, an English case which tries to explain the domain of this depravity and hardship, court tried to put forward certain examples of what a hardship or depravity would constitute. Some of the examples are desertion of the current wife and entering into adulterous relationship with other women. As we can also see in the picture, adultery with other women, promiscuous relationship with others. Then there is cruelty towards spouse. So husband comes all drunk and starts beating the woman. So these are all the instances of what a hardship or depravity would actually constitute. There's no foolproof formula or a straitjacket formula which would say, okay, these things had happened. Now this is exception depravity. Court has to determine it on the basis of facts and circumstance. Again, the next slide talks about the scope of an exceptional circumstance. So what happened in this case, called Vinod Arora versus Manju Delhi High Court judgment, it says that the exceptional circumstance has to be exceptional in all the senses. It is not something that we will say that okay, in this case what had happened that after 3 days of marriage the woman refused to have a sexual intercourse with the husband, and instead she went back to her matrimonial home without actually informing the husband. So, does it amount to an exceptional circumstance? Obviously not. It does not even amount to a ground for divorce, let alone an exceptional circumstance. So, court says that exceptional circumstance must be exceptional, must be so difficult that it is impossible for the spouses to live together. So, we can see it from an example. Suppose a husband comes all drunk, starts beating his wife without any reason, without any fault of hers. Of course, beating is not a good option, not an option which should be appreciated at any cost. But then cruelty is meted out to a wife for no fault of hers. So the court does not expect in such a circumstance that they would ask you that you will have to live with your husband even in such circumstances, because the law says what your time has to be elapsed. So it is not something which has to be mandatorily followed. This question has also been answered as to whether this time period of 1 year before filing of the divorce petition is mandatory or is it directory. So this judgment called Ravindranath Mukherjee versus Iti Mukherjee, opinionated by Justice Bhattacharjee, has been landmark in all its senses and actually has been followed in several of the judgments from here on. So what does this case say is okay. So the legislature had initially said that a 3 year time period must be given for the spouses to think about their marriage, but later this time was reduced and they said we will reduce this to 1 year. So 1 year time has been given so that the spouses can think about whether they can reconcile their differences or not. Also, if the legislature even had an intention to make this 1 year time period mandatory, what they would have done is that they would have instead amended the matrimonial legislations of other religions as well, say that of Christians and Parsis. But they did not do so. Does that mean that they did not want to actually kind of protect the sanctity of marriage of Christians and Parsis and other religious backgrounds? No, this does not mean that. Also, if suppose we happen to make 1 year time period before filing of divorce petition is mandatory, then as we had discussed earlier also, that even if we file a divorce petition on misrepresenting the fact, trying to lie to the court may still grant us the decree. So if we say that no, 1 year time period before granting of decree is necessary, this entire provision of the section would be defeated. We cannot say that legislature and their provisions is redundant. Every word that has been inserted in a statute has its own meaning, and we have to interpret it in that particular manner also as only. So that's why what this 1 year time period means is that 1 year time period is not required to be matched as if in case scale of precision, as if in mathematical precision, that okay, now 1 year time has been elapsed, now we will grant you a decree. It is not something that needs to be followed with such a precision. In view of the facts and circumstance, if it appears to the court that okay, the time is now, this is very difficult for them to live together, court may grant you a decree even before that. So there's no hard and fast rule. So my concluding statement would be that of course Hindu marriage is considered as a sacrament. It is a sacramental bond which should not be allowed to be dissolved due to some petty reasons. And therefore what this section tries to do is to prevent the spouses from trying to dissolve their marriage after every fight, after every small differences that may arise between them. But at the same time it also tries to dissolve the same marriage before 1 year period in view of the exceptional circumstances. So in all probability, no matter what angle we look at it through, section 14 is actually a purposeful section in all its senses. So that's pretty much the presentation. Thank you.